This is the clicker? Cool. All right, it's good to see everybody here. I was hoping for a bigger group. We are going to be doing a lot of trust falls tonight, some team building, so I hope you're all strong. Hopefully we can catch everyone. Just kidding. No plans for that. Yeah, let's jump into this. Let's figure out how this all works. Yeah. So this is put on by Elysium. It's a collection of, I know some of you are familiar, but it's a collection of professionals, different groups all under one roof. So attorneys, accountants, trust, or like title people all working together. One thing we like to do is to teach and to help others understand just some simple things. So not here for a sales pitch. I am an attorney, but I have no expectation that, I'm not here to sell my services. We are here to learn about business succession planning. And then, we want people to live their best life. And this is a little bit about me. As it says, I'm David. Connie, good to see you. I'm an attorney. I went to 2 different law schools. I went to Baylor University in Texas, got my JD, and then I liked law school so much, I went back and I got a Master of Laws from the University of Denver's Law School in taxation. Specialized in corporate taxation, so a lot about business taxes. My practice areas include estate planning, asset protection, gift and estate tax, charitable giving, business tax and structuring, and then tax-exempt organizations. And the last one's kind of my passion project. I love working with nonprofits, 501c3s, any other 501c4s, 508A1As. That's an interesting one. And then this is a picture of me. Does this have a laser pointer? Dang it. Yeah, it does. Does it? Dang it. You won't be able to see it on the TV. Oh, dang it. That's me. I like to run, so rather than picking a photo perfect professional one, that's me in my rawest form. This is mile 85 of a 100-mile race. And that mountain back there is that Simpanogus. So at this point, I hadn't slept in 26 hours. I was pretty over this whole experience, but that's me just doing my thing. And I love to get out. I live in Sandy, just straight east of here, with my wife and 2 daughters. So love doing that stuff. But yeah, let's jump into the bulk of this. After this, you will know the importance of business structure, which business structure to choose, because that does impact your exit strategy. Available tools. We're primarily going to discuss buy-sell agreements, and then the role of asset protection and estate planning. Kind of that idea, if you don't protect what you have, then why does an exit strategy even matter? So we'll talk about how to do that. And you'll be familiar with risks and pitfalls associated with these different planning ideas. You'll be proactive in your planning. Kind of the biggest, I always joke with clients, it's not really a joke, it's the truth. Best time to do this planning was 5 years ago. The next best time to do it is today. So that proactive approach is important. And then obviously we want to take the next steps, because these often require, it's not just knowing about it, it's doing it. That's the big part. But yeah, we're going to talk about primarily three different areas. Beginning with the end in mind, that's the entity choice area. We're going to talk about the different structures, pros and cons, primarily with exit strategy, marketability, things like that. We're going to talk about a buy-sell agreement. These are the bread and butter planning tool. I like to call them business premarital agreements. Basically, if you're going to get in business with somebody, you want to protect yourself for and if something happens. If it falls apart, you want to have everything in place. And then trust and estate planning. So estate planning would be the death part, and then trusts are a pretty versatile tool we can use for a lot of different things. And yeah, let's jump on in. Part 1, beginning with the end in mind. And feel free to ask questions as we go along. I love answering questions, so if you see something you're like, What does that mean? Feel free to just shout it out. So these are our 4 primary structures. Sole proprietorship. There's a lot of businesses that are still formed this way. This is basically just you being you and running a business. Partnership, it's 2 people running a business, 2 or more people. Corporation, this is like your bigger companies like Apple, things like that. And then LLCs, which stands for limited liability company. So let's discuss these 4 different types. All right, sole proprietorship. This is, I would describe it as business structure in its simplest form. It's just an individual running a business. They haven't formed an entity. They're just going out doing their thing. They're really easy to set up because it's just a single owner. But there's unlimited personal liability. So if that owner were to have some liability that arises, maybe an unpaid, some amount and like a lien against them, it's going to be against them personally. And so they're liable for any debts and obligations of their company. And this is often, like I mentioned, freelancers. This is like the handyman, somebody that's not super sophisticated, probably doesn't have a lot of liabilities. This would be a great fit. So minimal risk, minimal liabilities. Freelance writer was another one I could think of as an example. And then partnerships. These are, again, 2 or more individuals that are in business together. This is both a legal status, so you can form a partnership, but it's also a tax status. So if you're a partnership, you're going to be taxed in a certain way. 2 main types. There's a general partnership and a limited partnership. General is kind of the general partner has unlimited liability within that, and the limited partner, they have limited liabilities, as it suggests. They share in profits, losses. It's a flow-through entity, so you get the K1. Is anybody in a partnership here that's familiar with that? Nobody does the partnership thing. So they're really common. You might have an LLC that's taxed as a partnership. That's why I ask that. Many people are involved with that. They're really easy to form. You actually don't need to file anything. You can have like a handshake agreement that would form a partnership. So still you'd have that legal arrangement. But you may do something more formal like a partnership agreement that defines the rules of the road for those groups. These are really common for professional services where we want to share like fee structures or something like that. And so small businesses, multiple owners who want to pool resources and maybe expertise. In most states as well, professional services, they need to be clumped together. So traditionally, lawyers, office with lawyers, because that's how the rule states. You can't have that, but there are exceptions to that. And in Utah, we actually have a regulatory framework that's kind of branching out from that. It's a sandbox that's been approved by the Supreme Court, so we can do things within that differ from that. But traditionally, kind of everybody's together. Doctors are with doctors, and but yeah, they're pooling resources, but they're also trying to limit their own liability. So think of like each individual as their own risk. So that's pretty common there. Corporations. These are a separate legal entity. So the taxation of these differs slightly from a partnership. Partnership, again, it flows back through to the individual partners. This, you have a double taxation scheme, taxed at the corporate level, and then when it's distributed as a dividend to the shareholders, it's taxed again. Where it comes to liability, there's various requirements. I like this phrase, a distinct legal personality. They are kind of their own thing. And meaning they can enter their own contracts, they can be sue independently on behalf of their shareholders. This is, again, a better fit for medium to large businesses. Often if you're raising capital, you're probably involved in a corporation. So going through a funding round. And you still have limited personal liability. Shareholders aren't going to be liable for the corporation's debts or anything like that. And this, like, examples are Apple, Ford, so big companies. Publicly traded companies are always corporations. And there's a little bit of difference with, like, voting. You can structure your company a bit differently so that some have control, some don't, some have voting, some don't have voting. So a lot of flexibility in this model, which is why a lot of businesses love it. So this, and again, these are just sort of like broad overview of these, just so we can talk more about like the exit strategy. So I'm not going too in depth on like why each one is better than the other. And then the last one, super common one, limited liability company. As the name suggests, each of the members of this have limited liability, so they share resources, but they're not liable for the company's debts. A lot of people describe it as like a liability shield. So if there's a liability or a claim that arises out of the property, say it owns a building and somebody slips and falls, the individual owner of the LLC wouldn't be responsible for that claim if there was something against them. So it kind of stops at them. The company's assets would be at risk, obviously, but the individual wouldn't. Really popular, easy to set up, really flexible. You can choose different taxation schemes. Like you can be a partnership, or say it's just you in this LLC. You could be taxed as a disregarded entity, so just everything is as if it was you. A little bit, pretty straightforward approach. I think, has everybody in here formed an LLC? I feel like everybody's formed one. Everybody knows what's up. So owners are shielded from personal liability. Super easy to form. Pass-through taxation. These are really popular with small businesses, real estate ventures, again, professional services. There's a special designation for professional limited liability companies. You can do a PLLC. There's tax advantages. But so super straightforward approach.
What's the difference with the PLC?
So it's professional limited liability company. So there's this statutory framework that says these people can form a PLLC. And what it basically does is you can break each individual off, as each member has their own risk, basically. So if I was sued as an attorney for my own liabilities, my partner or the other member wouldn't be liable for my malpractice. That's kind of one of the elements of that. They're pretty common. That, like the PLLC or an LP, a limited partnership, that's your typical law firm setup. And then the last one is S Corp. This is not an entity type, it's a tax status. So I start with that because sometimes people get confused about that. But S Corp, there's different sub-chapters in the tax code. S is for this S corporation. And think of it as like a hybrid. It's kind of like a corporation. It's kind of like a partnership. It's that floating middle ground. These are often, so it combines those benefits. So it is passed through, much like an LLC or partnership. So tax consequences flow to the individual members, which is pretty favorable. People like that. There's only one tax level, not two like in a corporation. There are some specific eligibility requirements. Like it's got to be U.S. citizens, limited shareholders, 100, one class of stock. That's a big difference between an S Corp and a C Corp. The one class of stock, so you can't have like multiple voting rights. So if you want to have like a company and have different types of shareholders or different dividend or distribution options, the S Corp's not going to be the one for you. Where I usually suggest an S Corp is you've got a consulting company, and so it's mostly services based, and you want to take advantage of some of the S Corp features. Like, for example, you can pay yourself a salary out of an S Corp. And so doctors, for example, really like this model. They'll form their like PLLC, and then they'll get an S Corp designation just because the payroll taxes and things are more favorable within an S corp. So that's kind of that. Do you have a question?
I was just gonna ask what a C corp is then.
Yeah, subchapter C of the code is a C corp. That's your typical corporation. That's your double taxation. So corporation pays taxes at its level, and then the shareholders, when they receive a dividend, they'll pay their individual taxes. So if you think of favor, like double taxation versus single, that's really what it is. So, yeah. And the corporate tax rate right now is pretty favorable. It's 21%. So prior to that, people were not forming. Well, I mean, they've always been formed, but they are a pretty good model right now. Yeah, so I want to talk through the documents. These are the ones that are going to sort of control the rules of the road, maybe talk about your exit strategy within that, just how your business is governed. So sole proprietorship, generally there's nothing involved. Partnership, that's your partnership agreement. A corporation, bylaws, shareholder agreement. LLC is the operating agreement. So as you're forming these companies and considering things, these are like the other documents you want in addition to, your typical formation stuff. So yeah, partnership agreement. Again, it's the rules of the road. You're talking about operations. We're really trying to prevent misunderstanding. So it defines voting, who has control, who can sign on behalf of the company. Key elements that you look for as you go through a partnership agreement: capital contributions, profit sharing, decision making, dispute resolution, succession planning. So sometimes we'll talk through like partners' retirement, disability, death. So those big things will be covered in this. It could also be covered in a standalone document that we're going to spend a lot more time on, which is the buy-sell agreement. So kind of, you can cover a lot of things within a partnership agreement. And so as you form these, it's important to consider drafting one of these so you can address concerns. Again, it's as you get into business relationships, this is the document that when it all falls apart, you look to and see what happens next. Yeah.
On these ones, like, this isn't really like a do-it-yourself type of thing, right?
I mean, I would not. It's detailed enough. The tricky thing here, especially with partnership stuff, the tax consequences can be unique. Partnership tax tends to be intricate enough where there's a lot of pitfalls if you try to do it on your own. So yeah, having a good tax professional. And also along with that, like having an attorney draft, it's nice. Having an accountant on the payroll or in your, I was going to say Rolodex, but I'm not even that old. I'm not that old. But in like your phone, in your contacts, important because they're going to keep this thing running. With all of these entities, an important thing to note, because we're talking about like you've formed a business, you want to protect this business, is maintaining certain formalities. So corporations, there's things like you got to do minutes, you got to have certain meetings. There's certain statutory requirements once you form these to keep them up and running. One of the pitfalls that people run into is, say with an LLC, they form it, they just put the LLC funds in their personal bank account, and it doesn't look so much like an entity, it looks a lot like just an extension of themselves. There's a doctrine called the piercing the corporate veil. That's where basically you form this entity and the person suing you has found a way to pierce through what normally would be like a protective shield and come at you individually. What happens there is because you've disregarded certain formalities. You didn't file your renewal thing, which is super simple, but it happens all the time. Didn't file your renewal each year. You didn't maintain separate accounts. You didn't have a partnership agreement in place. So those kind of basic things that these boxes you want to check, like it seems like, oh yeah, it'd be nice to have. Oftentimes it's necessary to have. So if you're sued individually, the first thing that your defense counsel is going to say is, well, let's take a look at the partnership agreement. And if you can't produce certain things, there's going to be some red flags, and they may have that other party might have a great claim for piercing the corporate veil and coming at you individually. And what that does is if you think of everything as a risk pool, so if your entity has 500,000 in assets, but you individually have 2 million, if they can pierce through that corporate veil, what was a $500,000 risk is now a $2.5 million risk. So it's important to maintain those. Again, we're going to be looking for these documents as we're focused on, as if anything goes up in smoke. Bylaws, shareholder agreements, these are super complex documents generally. C corps tend to be, or corporations tend to be more involved. We're dealing with shareholders, so we have the shareholder level. We've got like usually a board of directors. There's going to be certain requirements or rules that govern how they act, what they can vote on, what their authority is. Key voting right, or key elements, voting rights, dividends, and again, within this, you might have multiple like types of stocks. So you might have one with a preferred dividend, meaning they're going to get paid out first before everybody else gets paid out. So if there's $100,000 for a dividend, but the preferred shares get the first $200,000, obviously all the other non-preferred shares, they're getting nothing down the road. So this would be the document you'd look to. So even if you're making an investment in one of these, it's often nice. Like I said, it's a smaller company. It's good to see what you're actually getting into. Transfer restrictions. This would say like you can or cannot transfer shares to certain individuals. Maybe first rights of refusal are in there. Shareholder disputes or disputes. This could be disputes among shareholders, or you're disputing something with the board of directors. Like they've decided because they hold all the preferred shares, they're going to sell first, and they're going to leave everybody else out in the cold. You may have certain rights as a shareholder that allow you to be made whole still. Basically, there's some provisions in documents that allow the little guy to still have a say if there's like a liquidation or something. So it's important to look through these, and then obviously buy-sell provisions may be in that rather than a standalone document. That would be like first rights of refusal. So if you decide you want to transfer your shares, that might trigger like, oh, we're actually going to buy them back from you because we don't want you to transfer it. Generally, in all of these, there's usually, with respect to transfers, at least when I draft them, there's a carve out for, you can transfer freely to like a family trust, to other like closely held businesses of your own. We're trying to it enables the owner to involve their own estate planning without going through like, oh, I got to consent from all the other people involved with this, and we make it a simpler process. Operating agreements, these are for an LLC, typically. Again, it defines the rights, obligations of members. So we're talking like these different businesses. Partnership, there's partners, that's each of the owners. With a corporation, all the owners are called shareholders. When we're talking LLC, it's usually members, and they have a membership interest. Could be a unit. That's often used in these documents. It's a unit holder. You might see that. But yeah, this is going to define like, well, we're saying we're a limited liability company. We're meeting certain statutory requirements. We're going to prevent disputes. Key elements, again, member roles and responsibilities, decision-making processes. Often with a LLC, it's like who can sign for the LLC. If you've got like 2 or 3 people involved, who can actually like write checks and make things happen. And it may be not a member role at all. It might be a manager's role. A really common structure is a member-manager LLC, where you have a member that's named, but the manager's controlling everything. We often see that with like an LLC that's holding your rental property. You'd have, say, one spouse on the document as the member, but maybe we don't want them both named for liability, to kind of bifurcate liability, so we named the other one as the manager. So kind of split up that role, limit risk to one rather than the other, but we give them both ability to control by saying we got a member and a manager. Really common structure.
If you want to change that, you have to like go into the LLC Utah webpage and change the manager
Yeah, so if there's a couple steps, you'd update your operating agreement, and then you'd file like an updated something with the state that says that. And these days, I didn't get into this in this presentation, there's the Corporate Transparency Act. So if you made that change, there'd be likely a change in beneficial owner. So you get to report that to the to FinCEN, which is the enforcement arm of, or an enforcement arm of the IRS. So, but yeah, that is if you want to get a bunch of attorneys and accountants really mad, bring up the Corporate Transparency Act and see what they do. It's not a great law, especially for small businesses. It hurts a lot of those. I wanted to talk about employment contracts. So this is not a governing document like we've been talking through. It's not. And so like really quick, S corps, they're going to either be a corporation taxed as an S corp. So corporations have two tax choices, C corp, S corp. So you're going to be looking to the bylaws for that. Or if it's an LLC can be taxed as a disregarded entity, a partnership, or an S corp. So where we were talking about S corps before, again, tax status, but the legal documents that would control an S corp would be an operating agreement or bylaws. So just clarity of a lot of terms, just making sure they're all in order. So this I bring up because we're kind of talking right now about what do we need to do to protect this business, to kind of plan for the future ahead. One of the pitfalls that I often see is like you start a new business and you're like, hey, the guy that did my web development, guy or gal, we don't have a lot to pay him. Let's just give him stock in this company or a membership interest in our company. That's an easy way. It'll grow. You'll get paid out eventually, and like it's probably one of the more annoying things. So say that company scales up. 5 years, it's gotten to the point where you're now looking to sell to some venture capital group. They've offered you the best deal you can imagine, but you have this random web developer on your cap table, and that buyer's like, well, what do we do now? And maybe it decreases the value of it. They're like, we don't want to deal with this. We don't want to deal with buying them out. So oftentimes there are a better way to handle that, maybe through an employment contract. Rather than just giving equity to everybody in a company, let's just make sure that we have got a solid employment contract in place. Things that describe their job duties, compensation, termination clauses, non-compete confidentiality, succession planning for key roles. So if you've got like an executive level, you can define compensation that isn't granting outright equity. There's a lot of different ways you can incentivize people rather than giving them just like, hey, here's a chunk of my company. Not a great thing. So, and then my big double stars, that means I really care about this. Just be careful who you bring into your company. As you're granting equity, don't just like throw it around like it's a holiday. It's not. It's going to be very problematic downstream. So use employment contracts. This is kind of where the exit strategy piece comes in. So we kind of talked through the differences. We understand the terminology, the documents that control. And this is kind of where the rubber meets the road on your exit. It's the marketability. So each of these entity types, they have their pros and cons. They benefit certain groups. They might incentivize others. Like we talked about, professional services are one area. But if you're looking to sell, so say you're beginning this company and you're like, my goal is to sell in 10 years for $10 million, whatever that number is. There are different types of entities that are more attractive to sell. Sole proprietorships, obviously nobody's going to want that. It's based solely on that individual. Probably you're not going to find a buyer for that. It's going to be very problematic. Partnerships, moderate. This largely depends on that partnership agreement. If the partnership agreement is really restrictive for the buyer, they're not going to want in on this company. So different types may be, so limited partnerships probably more attractive because limited partnerships have limited liability. So they might want something along those lines. This is also industry specific. So partnerships in one industry might be a more favorable entity type than an LLC or something. So you want to consult with somebody that knows the industry and say like, oh yeah, if you're in tech, you want to do it this way. Because they all have like a very specific way of doing their funding rounds. So yeah, and if in a partnership, they're going to look closely at like records of the company. They want to see like a track record of profitability. So as you're running this thing, you want to, if the plan is to sell, then if you've set it up as a partnership, you need to have really great books and records so that when you turn those over to the future buyer, they know exactly what they're getting into. And that's where, again, the accountant's a great person to have on speed dial in your Rolodex. And yeah, so partnerships, I'd say I put them as a moderate. This is kind of my ranking. Obviously, sole proprietorships, terrible. Well, not terrible, just you're not going to find a buyer for that. Moderate on partnerships, largely industry specific. LLC, again, it sort of depends. That's my favorite lawyer word. I had to find a place to put that in this presentation. It made its way right here. It's how I answer every question when somebody's like, yes or no, does this happen? I'm like, well, it depends. That's my answer every time. We're really good at that. So this is moderate to high, depending on the characteristics of the LLC. Again, industry specific. It does combine those liability protections, which people like. They're going to buy that. And yeah, a lot of people might buy it. This might come in play. So if you're selling an LLC, there's often like an asset sale where there's like, we don't really want the company itself. We just want everything you have. We want your client list. We want your equipment. We want your inventory, whatever it might be. They might buy it out that way. But still, LLCs, because they have that limited liability, there's a layer of interest and protection there for a future buyer. Again, strong management team. So you can build, LLCs are really flexible, so you can build them out as much as you want. So say you wanted a board of directors within that, or like CEOs, like different titles and different layers of management, you can do that, and that might be valuable. Especially like, I think of like things like intellectual property, clear growth strategy. That's what makes an LLC really attractive for sale. S-Corps. These are, again, I've got a little just recap of what they are. There are eligibility requirements. One of those is everybody has to be a U.S. citizen. So say you're in an industry that has like you're in, what's one that I've dealt with recently? You're like a distributor for Mexican goods or something like that. You might have an interest out of the country to invest in your company or to buy your company. They would not be a good fit for an S-Corp. You would be ineligible after they purchase to maintain that S election. So it doesn't really make sense for an S-Corp status. S-Corps, they do provide flexibility. I think of them, they're pretty appealing right now for like a closely held business or maybe a family-run business. They transfer very nicely to the next generation. Yeah, and there are some problems though. So again, they can be sold, they can be merged. There are a ton of ownership restrictions, and that's even like how you layer it within something. So can an S-Corp be owned by this type of entity? Can an S-Corp own this type of entity? And there's a ton of rules related to that. So S-Corps can be problematic when we're dealing with that. It does limit that pool. And there's a ton of tricky rules when it comes to a C-Corp going to S-Corp or S-Corp to C-Corp. So as you're looking at that, say I've got an S-Corp or I'm looking at buying an S-Corp, and I ask them about it, well, have you ever been a C-Corp? And they're like, oh yeah, we were a C-Corp 3-4 years ago. There's gonna be a whole host of tax issues that you have to address with built-in losses, built-in gains, and addressing all of those before, and it might affect like your decision to purchase it. And if you're running one of these and you've converted, that's always a consideration. You want to be like as thoughtful in your timetable of when you convert from that. And again, a lot of these are flexible. like mergers and acquisitions is an entire industry based on like, I want to take my LLC and use it within a C Corp or my C Corp and S Corp and moving things around and merging, acquiring.
So that is a possibility if you're a C corp to change it to something
To change your election, yeah.
newer.
Yeah, to the S Corp. Yeah, so that's an option. Yeah, and if you're going to IPO, that's initial public offering. That's where you're going from publicly or privately held to publicly held. Again, that is beyond the scope of this, but an S Corp might not be a great fit for that initially. But it's hard to have that foresight when you're like, okay, I've started this thing in my garage, and I'm going to IPO. That's a bit of a bold and it's an aggressive strategy, but I like it. If somebody came to me with that, I'd support it. Corporations, these are really popular, and there's a number of reasons why these are super popular. If the goal is to sell, again, all of these we can build in things that account for death, disability, those different other bumps in the road. If you're looking to sell, corporations are great. I put that as high. A lot of advantages. It's easy to transfer ownership. They can just buy all the stock. You can buy all the assets still. You can easily maintain or establish new governance structures. Strategic buyers, again, these are your VC groups. They really like to see this kind of stuff because of their scalability, easy to grow them, access to different markets, potential for growth. People like these. This has been really popular among a lot of people. Qualified small business stock, put a little asterisk there because we're going to discuss why that's important. But that is one of the things that makes these really, really attractive, a C Corp really attractive to a potential buyer. And let's talk about why. This is going to be a little bit tax heavy. This is under Section 1202 of the tax code. QSBS stands for Qualified Small Business Stock. So each of those words has meaning: qualified, small, business stock. So qualified, that's part of what makes, so we'll just jump down here to qualified. So you have to have a certain type of business to get this tax arrangement. But what QSBS does is it's significant tax benefits. It's basically when you sell down the road, so there's different tax strategies. Let me back up even more. There's like has anybody done it or familiar with like a 1031 where you exchange property, like kind exchange? So that's a tax deferral strategy, or like a 401k is a tax deferral strategy. You just kick the can down the road. Say, I'll pay the tax when it's more favorable, maybe because you're earning a bunch of money and taking that distribution out later on when you're not earning a bunch of money, better tax results. 1031, you don't pay tax on the sale of the property. You say, hey, I'm going to exchange this for something, avoid paying tax now, but I will pay tax down the road. And then so that's a deferral. And then there's just exclusions, like you'd have something that says like if you sold your home, you have your principal residence exclusion that says, hey, there's a capital gain owing, like you can take off $250,000 of that because of this principal residence exclusion per person. And then there's just like, we're not even going to consider this as tax. We're just going to say no tax is owing. That's what this does. So it's a tax elimination strategy, you could call it. But it's tricky to qualify for this. So as you're forming businesses that say you're going to sell to a VC group, QSBS stock should be on your mind as an option. So eligibility, you got to meet these really specific requirements. Has to be a C Corp, not an S Corp, not an LLC. It's a C Corp. The assets have to be less than 50 million. So that's kind of the qualified small business stock, less than 50 million in total assets. It's got to be an active business. So this isn't a holding company. You can't just form something as an offshoot and hope that you're going to qualify for this. The business is qualified. So I put two buckets that we can look at. Permissible, kind of your ones are manufacturing, retail, technology, wholesaling. So the tech one is big with Silicon Slopes. That's why we hear about this all the time. I get a lot of questions about this. Impermissible, and this is pretty broad. So personal services, so a law firm where you're providing services, that's not going to count. Retail, banking doesn't count. Insurance doesn't count. Financing, leasing, investing, forming, mining, or this is one that comes up, operating a hotel, motel, or restaurant. So personal services, things that like you're leasing to somebody, that's all not available, which covers a lot of stuff. But if you're in one of these other things, and there's a whole host of case law out there and different rulings by tax courts that say like, oh, this looks more like personal services than it does. Like for example, if I form a company and we're holding real estate and it doesn't really look like a real estate thing, it looks more like a hotel because we're doing like micro leases, you're probably not going to qualify. It's got to be in exchange for property. So this is original issue is one of the rules. So it can't be like, oh, I'm coming into this company, so I'm going to buy some shares from somebody. It's got to be original issue. So from the company to your hands is the rule. So this is often founder stock, people that came in early. They can receive it as pay for services. So the note I had is if you acquire it from another person, you're not going to qualify. However, it can be gifted. And again, we have an asterisk here because there's some cool trust things you can do through gifting. So the stock can be gifted and you can maintain the status, which is helpful. But QSBS is big. I know right now with talking with other professionals, it seems that if a buyer is going to come after your tech business, they expect it to be eligible for QSBS treatment. This is the tax consequences. So the excludable gain is limited to the greater of 10 million or 10 times basis. Does everybody know what basis is? When you buy something, it's worth 10 million. Or you buy it for 10 million, that's your cost basis. So we'll use stock. You bought a stock for $1. Your cost basis is $1. If it increases over time to $100 and you sell that thing, that's the number we use in the calculation. So you'd have an amount realized of $100 minus less your adjusted basis, which would be $1. So you'd have $99 of gain realized. And then we ask, is it recognized? And that's where we look to, is it a capital asset? And if it is, it's taxed at 20%. So you pay like $19 in taxes based on that. So the number that they're going to use is 10 million or 10 times basis. So say your basis is 10 million, you got 100 million of excludable gain. Kind of a big number. So here's our example. John purchased 5 million of QSBS shares in an XYZ Tech. In 2017, he held on to it for more than 5 years. So there's a holding period that's required. So you have to wait 5 years before you sell it. So again, it's worth getting this in early. If your target's like, I'm going to sell in 6 years, you have to do this in year 2 and make sure you're eligible in year 2. You hold them for 5 years and he sells them in 2023 because he's hit that holding period. Value's increased to 25 million. So he sold it for $25 million. Without John pays, this is our tax equation. Amount realized, that's what he got for it, 25 million. Minus his adjusted basis or less his adjusted basis. And we know he paid 5 million, so his cost basis is 5 million. So he'd have a $20 million gain recognized. And then we multiply that by our tax rate. The federal rate's 20%, state rate is 4.95%. So 24.95. So he's going to pay a tax bill of $4.99 million. With the QSBS treatment, he gets to exclude up to 100% of the capital gains from the sale. So his federal income tax is $0. It's a pretty good day. So save $5 million just because of the nature of that stock. That's why people really like this. Easy win. We love QSBS stock. And this is technical enough where it's worth getting a professional involved, whether that's your CPA or an attorney that's comfortable with this. Yeah.
So did I understand it right that 20 was the federal and 4.95 was the state?
Yeah.
So would he still have to pay the 4.95 to
Yep.
the state?
No.
Okay, cool.
No. Well, maybe. No, I don't think so. I think they're unified systems. That's a good question. There might be some state tax owing, actually. So that's a good point. Yeah. But yeah, either way, that's a pretty good tax day, in my opinion. But yeah, that was just kind of the entity types. Again, QSBS, wanted to share that. That's a biggie these days. Buy-sell agreements. This is, again, that premarital agreement for your business. So let's jump in. This might, we'll go quicker through this. I think the slides are simpler. So this is asking that question. It's like, okay, it can address like conflict between surviving owners and family. Keep in mind, this is like you've got a business partner. It's not going to be your family member. It's somebody else. We're going to ask, okay, what if one of you dies? Does the estate, like you don't want the estate or these like 5 kids, say they had 5 kids, now becoming owners with you. You want some mechanism to either buy them out or change that ownership or keep things consistent. Again, concerns of employees and creditors, lack of market. We can kind of create an artificial market for a business that normally wouldn't be sellable or would have a difficult time selling. We can talk about how we do that. Valuation difficulties. Sometimes it's like, how do we know how much this business is worth? Like, what do I pay to this person's estate? Again, lack of income for families. So somebody's on disability or unable to work, or they've died. How do we compensate the family for this previous partner's portion of the shares? And then this, I always think it covers the 4 Ds: death, disability, divorce, and departure. Divorce is one that's like, you don't really, so say that like one of your partners gets divorced and his or her spouse is awarded half of that partner's shares. Now you've got an angry ex that's now a quarter owner of this company. That's a bad day. So we want to avoid those things. Buy-sell, it's a contract between the members, typically of an LLC, and it defines what happens in certain triggering events. It provides a framework, prevents disputes, that's the rules of the road. If things fall apart, we look to this document. We already know what to do. And ensures continuity. These disputes, we often resolve a lot of this early on. It's usually a negotiated portion. If it's, say we've got 2 partners that have differing things, they both get attorneys, we negotiate it out. It's way simpler than fighting about it in the courts later on. So we can prevent disputes by really defining what it is early on.
Do you need a buy-sell, so we have LLCs for like a rental property. Would an operating agreement cover that, or would a buy-sell be?
Yeah, so are you involved with those with parties that?
It's just me and him.
Yeah, so between spouses, you're probably good.
Okay.
Yeah,
Just an operating agreement.
Yeah, so where you've got like a person you're just in business with, outside of like a marriage is going to have different property rights anyway, and most of the time you'll be on board with the same thing. But if like you weren't on board, maybe a buy-sell is a good thing to have. But most of the time it's, I've got a partner. You might trust him a lot, but at the same time you're like, I don't really trust him, or whatever it might be. Yeah. So we're going to put a buy-sell agreement in place. We're going to just define exactly what's happening. Again, think premarital agreement for a business. If this goes to crap, we're defining what happens. So it also dictates things like, do other members have the option to purchase it out, or can that person sell to a third party? So transferring ownership interest, big part of these documents. And that ownership change. So often in this, we're going to say like, yeah, you can transfer to a family trust, but if you try to transfer to a third party, I get a first crack at it because I want to own this thing 100%. And then we'll have it predefined what that value is.
Good question back here.
Yeah.
So, is it advisable to have a separate
Yeah, that's a good question. So we'd often integrate the two. So buy-sell agreement is, so an operating agreement, you can change it pretty easily. This you can still change it, but there's a little less flexibility within this. Normally we integrate the two. So if there's a provision in the operating agreement that discusses like non-voting interest versus voting interest, this might apply to just voting interests. And so, or if there's like a non-compete agreement in the operating agreement, we might integrate that same thing. We might say that anybody that signs this document is also agreeing to all the terms of an operating agreement. The operating agreement might define how we change this if we're going to change it. So members can change it based on some vote. So yeah, they're all integrated documents. So generally when we do a buy-sell, if somebody came to me and they're like, oh, I want a buy-sell agreement, I'm often going to tell them, we're going to redo your operating agreement so that they, like, when I reference this in your operating agreement, it's all seamless and all the little, everything fits together nice. And that's how I sleep at night, honestly. It's knowing that everything fits together well at night. Or well in these operating agreements. And it gives me anxiety when they don't. Yeah, so buy-sell agreements, again, we're defining certain things. Valuation, big part of it. This, again, there's some different options for valuation. So one of the often disputed items when a partner wants to exit or a member wants to exit an LLC is, what is this thing even worth? And sometimes it's easy. Say it's real property. You own just real property. It's pretty much the value of the real property. But it gets a little bit more complex when you have client lists. There's accounts receivable still that are unpaid, and there's all these other elements that we're looking at. It's harder to look at or harder to know what its value is. So first is you can specify in this thing a predetermined price. It's like, we'll buy you out for $1 million or whatever it might be. So we just fix that price. And maybe you have a phrase in there. It's like, we're going to adjust this every 5 years as we grow or shrink. So we have this like moving target, but it's just a fixed number. Formula-based, this would be earnings, like something you have to see is like 10 times EBITDA, which is earnings before interest, taxes, whatever else that acronym is. You might have a phrase like that. So we're just going to fix the value at something based on your books at the time. Or the last one, these ones are not the best because they tend to be pricier. Like you say, every 2 years we're going to do an independent third-party valuation. If it's kind of a contentious partnership, like you're making money so you're happy enough, the issue you're going to run in, or you might want to do this where you've got just a neutral third party that comes in and says, hey, this is what it's going to be worth. But yeah, those are our valuation things. And we have like a specific provision or set of provisions that really define what that is. But then you know what you're getting into. The next question you might be having is, okay, well, that's well and good, but what if it says $1 million? I don't have $1 million to buy this person out if they're say disabled. So maybe after you have a provision that says if a partner is disabled or hasn't worked in 9 months, then we have the option to buy them out. So taking that unproductive member and giving us a mechanism to get them out of there. So that's one thing, or like the divorced spouse, making sure we can buy out their shares or the ex's shares so that we don't have to deal with him or her as part of this business. Yeah, so cash reserves, you could have something set aside. You could use a promissory note. That's really common. Life insurance is really common where the business will pay the premiums on a life insurance policy. So if partner dies, company gets the life insurance proceeds to buy them out. So the nice thing about that is family's taken care of. They still get some value and they can move on. Or a sinking fund, portion of the profits go for the purpose of funding. Restrictions on transfer, this is like, and I'm going to go quick because we're running out of time. Yeah, so restrictions, right of first refusal, saying if they're going to sell, then you get to buy first. Spousal consent, this is something I often do, where at the time of execution we have that spouse sign something that says, yeah, I agree to the terms of this, so that if there's a subsequent divorce, it's already taken care of. It's not even at issue in the divorce. Or it might be, but it's already been mitigated by their consent. And then I like to do stuff with trusts as well. Advantages, liquidity for the member. We have something that's built in, whether that's cash reserves. We've got life insurance if it's a death. And then we've got some formula to determine that price. You can maintain control easier. Obviously, we're preventing disputes among members, heirs, exes, whatever that might be, and clear rules of transitions. And yeah, really the thing is, like, it's just smooth. I think of it as like a turnkey approach. Like, you don't have to go battle it out anymore. You could even have provisions that clarify, hey, if it does fall apart, we're going to mediate before we go to court, or use like alternative dispute mechanisms. Really just that smooth transition, minimizing conflict. Disadvantages, it is costly. Typically you want an attorney to set it up. There's some complexities with drafting. Funding challenges, again, liquidity might be an issue. You might not have the cash, and so often a promissory note is the preferred way to go, because you don't have cash on hand, so you're going to be paying them out over a number of years. Some people don't like that. May strain the finances if cash reserves are limited. And then first rights of refusal may deter potential buyers. We talked about marketability. That would be one of those things that's concerning. And it may require like an amendment of everything to make it happen. Buy-sells, tailored to the specific needs. It's not just kind of like a drop-in-place, simple. It's not the Macy's suit approach. You're not just going to get a buy-sell agreement that some other LLC had. It's going to be your tailored approach. I do note life insurance, so valuations can be pricey. There's a lot of companies that offer, life insurance companies that say, hey, we'll value your company for free if you buy our life insurance. So it's kind of their trade-off, but it can be really helpful, kind of a one-stop shop for your life insurance stuff. And then it does require reviews as you're adding new partners, changing things, goals change. We update that. And then obviously there's the disclaimer of you probably should consult with the attorney or financial advisor if you're going to be doing one of these. And then, I want to talk briefly, kind of out of time on this one. This is my favorite stuff. This is what I primarily do. Trust and estate planning. Obviously, the Benjamin Franklin said it best, there's nothing certain in life but death and taxes. When we're thinking exit strategy, there's one that you know is going to happen, and that's you're going to die at some point. It's one you can all plan for now. You might not be able to sell your company, but you're definitely going to die at some point, which is annoying because I always advise my clients of this one simple trick to avoid all of these issues, and that's immortality, but not a single one of them has figured that out. So kind of annoying. I'm hoping that one day somebody does, but right now everybody's going to die. Orderly transfer of assets. This is kind of why we do it. Minimizes tax liabilities. There may be estate taxes owing. You can protect the business through trust planning. We can integrate things like QSBS. That 10 million rule, we call it stacking and packing. You can stack trusts with 10 million each, for example, with QSBS stock. So you take that 10 million, you magnify it across multiple trusts, make it into 100 million pretty easily. So you can do a lot of unique things with QSBS planning and other things. Again, we've got wills, living trusts, powers of attorney. These are kind of the hallmarks of estate planning. Powers of attorney would be like you're incapacitated, somebody can still manage those business assets on your behalf. So we're really focused here on protecting what you've already done as we're looking to pass it on to the next generation. And then we've got irrevocable trusts, cover a variety of tax strategies. I would say these are the bread and butter of tax planning these days is a good trust that is tailored to your things. You can also do charitable giving within that. This is unique to Utah, or there's like 17 or 18 states that have these. They're asset protection trusts. You can put your business in there or your house or something, or your house and leave the business out. But these allow you really strong creditor liability protection, and you can retain some control. So really great tool to have in your toolbox as you're looking at protecting things.
David, if you have like two partners, can they both put
Their share?
ownership in their own trust?
Sure, yeah. Yeah. Yeah, you just gift in what you got. There are tax consequences when you've got an irrevocable trust. You probably should consult a tax professional. And then depending on how they're structured, you might do a lot of estate tax savings. Estate taxes owing if you have more than $13.6 million, doubled up for spouses, so 27.2. But if your business is growing at a fast rate, you can chuck your business in one of these, and you can avoid the estate tax on all that growth that might happen with that business. So you can do a lot of tax savings, and it adds up quick. But that's pretty much it. That was my whole thing. We've got these other lovely people that will be sharing with us soon. So put those on your calendar. Any questions? We are out of time, but I'm happy to answer any questions